Every day in the USA, people find themselves in court.
Desmond Harper, Mr. Matuska.
Present, Your Honor.
Okay, what are we going to do today? He's got 1, 2, 3, 4, 5, 5 cases. It says MTRP hearing. Is that what we're doing?
Yes.
Okay, then it appears as though Desmond Harper is the guest of honor. Let's bring Desmond Harper out and let's move on those. 1, 2, looks like 2 cases that the defendant is on probation for, and then there are 3 new cases that have been filed. Really? I'm looking at, I only have 3. 5 total. Two on probation and 3 new ones.
He's not very happy. He doesn't want to come out, and he doesn't want to speak to the attorney either.
He didn't have a choice.
Okay, are we good?
Okay. I mean, we would never get anywhere if that was happening.
Here's your honor.
Right up here.
Okay, you're Desmond Harper, sir? Is that right? You're Desmond Harper? Okay, just, the defendant is going to, we'll put the defendant right there in the jury box. And Ryan, you can have a seat there. We're going to move forward without, the court will note, this is Desmond Harper. 2 cases, or motions to revoke probation in 23 F 23-41343 and 23 CR 580. We will move forward on these motions to revoke probation. There are 3 new cases. Aggravated assault with a deadly weapon, unlawful possession of a firearm by a felon, and another aggravated assault. Those will be placed on the trial docket. As far as the motions to revoke unadjudicated probation are concerned, what says the state in these 2 cases? Which are 41343 and 23 CR 580.
Your Honor, the state has a couple of the officers here to testify. The actual complainants in that, the defendant has been contacting via his mother both of the complainants on numerous occasions, probably 30 or 40 between jail calls and kiosk messages.
So he's communicating when he's in the jail, but when he comes out here in the courtroom, he's going to stay on mute, which is, the rules are built to work around that problem. And all that is admissible.
And he's asked them to essentially sign affidavits of non-prosecution and say
Okay.
that the weapon was there. The only reason why I'm saying this is the complainants are not here. And I spoke with one of them, said she's scared and she is not appearing. We're having a hard time getting her due to his communications through his mother.
Subpoena her, and I'll just order if
Here, man. Hey, man, let me line, man.
get him out of here.
Yeah.
Get him out of here. We will work around it.
Man.
You are inappropriate. You are inappropriate. Get orders. Obviously, he's abusive, obstructionist, and is attempting to manipulate the whole system by attempting to intimidate people. And we will do what we need to do. We'll have a hearing, leave him at the jail, do a Zoom, and then the people can be here, and so they don't have to be close to him because of fear from his obstructionist acts and his threats of reprisals or threatening behavior. And those people will be ordered to appear. Get me a court order. And it's obvious that the defendants, every defendant like this, bullied their way through the system that they would control. And then the rule of law would not be applicable. The rules of law state these are matters to be heard and will be dealt with under the rules of evidence. And a defendant cannot take over the system by being rude and abusive. What are you saying, Mr. Matuska?
Your Honor, if I may, I did attempt to speak with my client this morning or just a minute ago, and he was not willing to communicate with me.
He's a grown-up. He didn't have to talk to you, and there's not much we can really do when they want to obstruct and try to take over the proceedings, which is not allowed. But either he's going to be following the rules, or he'll have to be put in a place where it's obvious he is aggressive and people cannot be in harm's way who are just trying to do their jobs under the rule of law.
Can we ask that he be ordered not to be able to use the phone except to talk to his attorney?
That's true. That will
Until
be
there's
ordered. He's not allowed to have any use of the phone privileges except for purposes of speaking to his lawyer. Thank you. That is only fair. What else?
Your Honor, do you want us to go ahead and start? If there's any?
Well, I mean, is anybody here?
Yes, Your Honor.
Oh, okay.
So, Detective Mindy Freeman.
Well, the defendant needs to be somehow
Some capacity,
present
sir.
in a capacity.
Yes, sir.
And if he's going to be abusive, then we'll just keep him over in the jail and
Okay, yes, sir.
do Zoom.
You have to enter certain findings to move forward without, whatever you do in that regard, Judge. I know you're familiar with that, but it's out of the ordinary, so I just wanted to bring that to your attention.
I think one of the holding cells has capabilities for them to hear what's happening. But I don't know which one.
He still needs to see. And bring Mr. Harper out again, please. We'll see what he wants to do. Otherwise, we'll just have to redo it and put him in. Do it through the Zoom at the jail. Mr. Harper, we're going to begin these hearings and you have to follow the rules of behavior. Do you understand?
Follow
can't
the rules.
interrupt.
I ain't broke no law. I ain't even guilty of the
Are you
charge.
going to
I have
follow the
probation for
rules
these
of-
hearings being held.
Are you going to follow the
I'm
rules
not gonna
of
follow
behavior?
nothing. I
All
want
right.
a motion for recusal
All
of
right.
another judge,
Then,
another courtroom. I'm not gonna sit up here and let you
all right,
just
here's what
give
we
me
will
20
do.
years for nothing.
Here's what we will do. You don't get 20 years for nothing. You
Yes,
get
for
20
nothing.
years for
You
your
don't
life.
get 20 years.
This isn't
for
a debate.
nothing.
That's enough. If you're not going to be polite and you're not going to follow the rules.
I'm
then
not
we
gonna
will
be polite
hold
to
the
my trying to
Zoom.
give me 20 years, man.
The
Why don't you
Zoom-
just get these other guys out the way? I'm following the motion. I'm not gonna, I don't want you to be my judge.
Okay,
You
the
said
motion is denied.
a lawyer said me and lied and said I threatened him. I have a CEO that is willing to come down here and testify.
You'll be able to.
Yes,
be
he's
able
willing
to
to
be
come down here
heard.
and testify that I did not threaten that lawyer.
We're going to do it this way. You will be held at the jail. We will bring you into the Zoom room. We will have the hearing. If you obstruct, we will mute. You'll be able to hear and see, but we're going
And
to
I'm
have a
still following the
hearing.
motion.
You're-
You can't deny me to follow the motion for
It is,
recusal.
you
But
can't,
somebody just said I
you
threatened
can
him
file.
and you said up here and told me that I'm violent.
Sir.
So you telling me you got my life in your hands.
you're
for
being
something that
abusive
you
right
ain't- I ain't even
now.
got a trial or you
You're
gotta
being-
give me a trial. Where's my motion for discovery? Where's my
You know, if there
motion
was a
where's
crime
my,
for
did I pick
rudeness, if
my
there was a
jury?
crime for rudeness,
Man,
you'd
listen,
be-
man, I
you'd
don't
be
care about none
guilty
of what
of
you
it.
talk about. I don't care
See,
about your courtroom.
I guess-
It's unlawful,
I know,
it's
that's
perverted to justice.
You don't care. That's right. You
I
don't
don't care
but
about
we're
none
gonna
of
follow
that.
the rule.
What are you telling me right now? This is
We're
my
gonna
life,
have
not
a
yours.
hearing. We'll be in the Zoom.
Yeah.
You file a
I'm
motion,
following the motion.
it's
I
denied.
guarantee I'll get out of here.
It will be denied and
Do
we'll
it
still
won't,
have the
do it won't.
hearing.
I have NAACP and everybody up in them.
Okay,
Yeah.
you're gonna
You
threaten
got a
everybody?
sex case, don't
You're
you?
gonna threaten
Don't you got I'm
everybody?
not threatening. Don't you got a sex
You're
case?
gonna
Why are you a
threaten
judge? You're a rapist.
That's all.
Come on, let's go.
He's out of here.
Fuck I got going on, man. Fuck
And
the fuck.
you're
I ain't going on
vulgar
none of that shit.
and you're a vulgar.
Shut up.
This man is obviously someone who is used to being in control of his environment. And like all of us, we have to follow the rules. He doesn't like that. He obviously wants to be in absolute control. We will work around that. He will be placed in the jail, continue to place in the jail. We will have a hearing. We will go through Zoom and he will be in the room or not, but we will move forward. The court, it's obvious, and it will be all it was a shout fest by the defendant who wishes to control the proceedings and in an aggressive, demanding, threatening tone. He has sprayed abuse toward the rules of decorum as well as the rules of evidence and procedure. but a defendant is not allowed to be obstreperous to the proceedings and just be violently aggressive. And then that will mean that the proceedings cannot move forward. It will move forward. It's obvious that he is dangerous and aggressive and threatening and wants to control the proceedings. Thus, it will be a hearing held through Zoom. He will stay at the jail and we will proceed that way. He can be quiet and polite, or he can be abusive. If he wants to be abusive, then he can be muted so that it does not interrupt the proceedings. But it's obvious, he wants everything on his terms like a child. It was just like a 4-year-old or 5-year-old having a temper tantrum, which has no place in the courtroom. And no way we can handle any proceedings if people acted like that. But we will move forward nonetheless, and we will have it that way in Zoom. I want to have this reset for a hearing in maybe next week,
We'll do the best we can.
and
Yeah.
we'll alert you.
We can do two. I'll be in Milwaukee next week on a federal training.
How about week after next?
Yes, sir.
All right. Mr. Matuska, go ahead as his defense attorney. What do you want to place into the record?
Your Honor, only that I attempted communication with my client. He's not at this time wanting to communicate with me. I only that know he wants to deny both allegations.
Okay. Well, thing is, my raising a childlike fit and shouting over everyone, it's obvious that nothing can be done. And that's why everybody gets a chance to be heard fairly, and the rules of procedure, criminal procedure, and the rules of evidence apply. But you can see why people like Mr. Harper, who control things, would turn this whole world into chaotic mess where nothing can be accomplished except on his terms. But we're going to move forward, and he may not like it, but that is not the test under law. I think every defendant up here is unhappy to be up here. I can't think of any of the defendants are enjoying their time in custody. So people are given leeway to vent a little, but not control in a loud, angry, aggressive fashion. And that's not domestic tranquility as the Constitution states it should be. Establishing justice, ensuring domestic tranquility. All of those are part of the preamble of the Constitution, which Mr. Harper is abusing. All right, we will reset in 2 weeks, and we're moving on this hearing on this motion to revoke probation. And I think you said something about a motion to recuse. That's denied.
Don't know the grounds for that.
No, I don't, well, the grounds seem to be, as he stated them, that things are not being conducted on his terms as he would like, which is.
Yeah, just to let the court know, I don't need kiosks or communications through electronic mediums. I go to the jail, so you don't have to modify the order for me.
Okay, well, let's say that. What do you mean?
I'll visit the jail in person. I won't use any kiosks or emails.
Okay, thank you. All right. All right, let's get Mr. Harper. He's on probation for 2 cases, and there's 3 others, right, that are new? 2 cases are called 23 CR. 23 CR.
He's quiet. Doesn't matter. You're gonna sit there for this hearing. I sit for no hearing if I don't want the lawyer. You can do it, Judge.
I'm firing
Order,
him.
you're ordered to sit next to your lawyer.
I'm firing him. He fired.
All right.
A lawsuit on
You,
you
are
and
you,
everything.
all right, you sit there and
Not
represent
doing no
yourself.
hearing with y'all, with his lawyer.
Represent yourself.
No, I'm not. I got a right to have a lawyer.
Not when you can.
Man, you got me, man. I'm getting a lawyer, man. You can't tell me. You can't tell me.
Yes,
what
I
you
can,
ain't
sir.
bigger than the law.
Yes, I can.
You can't, man. No, you
You're
can't.
held in custody. You are held.
You got me on right.
Now
What
you
we
are
talking
charged
about?
180 days in the county jail for your vulgarity, for your obstinance, and for your disregard for all law and proper behavior.
And Your Honor, this happened last time. And I
We're
think
gonna,
he's-
next time, we're gonna bring him out. We're gonna have him gagged.
Well, it's very
And-
difficult for us to get the witness here. He's repeatedly, you ordered him last time not to contact her after he tried to get her not to prosecute. And he has been contacting her over 109 times we have.
We need to put all that on the record, but what we'll do is we'll put him in a cubicle or something where we gotta figure out how to do that. Where he's separated and he is gagged so that he cannot make outbursts. We gotta figure out a way to do that.
I think what Mr. Boyd's asking is that we take some of those measures today. Because
You will find, how do you propose we do that?
Well,
You got a plan?
That's gonna be possible from the sheriff's office.
I defer to her. I was on that.
As far as at the jail, him not being able to.
Judge, you don't like it when somebody's,
Prohibit the further communication.
Right, how are we gonna keep him from, because he's still been contacting her right through different accounts.
Correct. He's been using other inmates' phone accounts, and when I finally contacted the control room officers in maximum security, told them to turn the phone off when he's in the day room. He then has the inmate in the adjoining day room make a phone call and just speak back and forth, relay information.
Okay, well, he is combative and he's not going to follow. It's obvious he's invoked his statements that were clear that he isn't going to be peaceful in any way. So we've got to fix a presentation to where he is separated from harm to others, but he is present in the hearing. And I think what we can do is just do it from the jail, I think, and do it by video.
Judge, we asked the jail if that's something that we could do and they said no.
And Your Honor, I believe you had suggested last time that Mr. Matuska maybe do it via Zoom and the defendant be in court. I think that was a.
Well, you can see what he does in court.
Yes, and I
So what do we do?
was just letting the.
What do we do? I mean, he's
is there a means in which he can hear but still be contained? Because here's the problem, Judge, and the reason why I'm speaking of is we're really having difficulty getting this victim here.
Yes, sir.
They're present today. We really need to get this testimony.
okay, but we've got to have civility and the outburst. We've got to control him. He is combative
Yes, sir.
and erratic.
Is there a way that we can pipe in where he hears what's taking place in the holding cell so that he's present in that regard?
I don't know if look, whatever I'm about to do when we're doing something in restraining defendants, he is on regular probation on one case, right? Or he's on deferred. No, he's on deferred on both cases. Okay.
And Your Honor, with that, he
So
only.
he hadn't been found guilty. I mean, if he was on regular probation, I think we would have some more rights.
Well, and that was the same victim, Your Honor, and that's the only reason why I received, I'm sorry, but she didn't want to prosecute last time. Yes, sir.
The point being is that the decisions the court makes on keeping him from being abusive and disruptive maybe are different from when he's found guilty on a regular probation than being placed on deferred or unadjudicated probation. But I'm open to whatever everybody agrees that can be done to hasten this along, because the way it is, I mean, he can just have an outburst like a child and outshout everybody and then the rules don't apply to him, but I want him jacketed. I want him in a jacket. And I want him, gagged if I have to, and then he will take his gag off, but he can listen. He has a right to listen.
Judge,
But
we-
I want him restrained and gagged. And when he has a chance to be heard, we'll hear what he has to say. And then we'll gag him back when they're through. So he doesn't control the proceedings. If anybody has another idea, let me know.
Your Honor, Mr. Harper's extremely aggressive towards his defense attorney.
You're not gonna be near him. You're gonna be.
No, that's not what I'm getting at. I'm just saying that possibly another attorney might be something that comes.
How could we possibly, what have you thought you've done that would cause him to be angry with you?
I'm only
No, what?
listening to what he's voicing for either representing himself or having another attorney. I seem to aggravate.
No, they don't get to pick attorneys.
Yes,
He
sir.
can hire somebody, but he can't pick one. And you're a competent lawyer. That's what I find. It's, and we open the door for one, we open the door for everybody. If they just want to change lawyers, there's theoretically no end to it. If there isn't a rule that's based upon good cause, and he hadn't stated any good cause. And I know you to be a fine lawyer, so
You know, I think I'm his first lawyer.
doesn't matter what difference.
I'm just trying to find a solution.
He
Your
does,
Honor.
but he doesn't get to select. And you open the door for whatever reason, and it wouldn't be hard for them to figure out, oh, I just don't like him either, and him, and her, and him. I mean, there would be no end to it. We can't open the door unless there's some good cause that's objective, not subjective, by someone who is indigent, who isn't. Yes, it's absolute right to have a competent lawyer.
But I do know that one of our holding cells, we do have the audio that kind of pipes in
I
there.
know, but there's no video.
Or though, if I may, he has expressed his desire to represent himself, and I think that creates a problem.
Well, no, he's entitled to, but it has to be, the court has to have findings that he obviously doesn't agree with and outshouts everybody.
That's why he's got a gag, Judge. He's gonna try to control the courtroom with his mouth.
Well, what do you suggest we do?
I believe that there's case law out there.
What do you suggest we do? How do we practically do this in this courtroom? I don't have a bulletproof, transparent cubicle, see, which is what would be handy, right?
About 13 years ago, we had two very combative inmates up here from TDC. We had to gag them, we used tape.
Yeah, we could gag him, but at some point, he's going to get to speak. He has a fair opportunity to be heard. Then what do we do?
Oh, I'm fine with that, giving him an opportunity to speak. I just don't want him derailing the process. to where
What do
he
you
can't-
suggest we do under what we've just seen? How do you propose it be done?
I want him gagged and I want us to get this witness.
Well, how do you want this done? I mean, it's going to be more than gag. He's got to be restrained.
He can be cuffed, Judge. There's not a jury. We
He's gotta
can
be
bolt him to
restrained.
the ground.
We were just informed by our major and our sergeant, he's not gonna be gagged. And we told him to come up here so we can get this handled.
Okay. Okay.
I believe there's case law that allows you to gag them, Judge,
Well,
especially after. the
you've got to
kind
do
of offers
something
that
to
we saw here.
prevent a defendant from making a mockery of the whole system and being just 100% disruptive.
And
Now, but they have in light of that, they have a right to be present for proceedings that affect their freedom. So,
Right.
and in a perfect world, you put them in a cubicle that is soundproof and you allow them to speak and they can hear. And when they speak or become disruptive, then you mute the sound.
Your Honor, he's not objecting to the proceeding. He's objecting to representing himself and having me as his lawyer. That's all I heard.
That is true. I heard the same.
Are you saying if you disappear, he'll be okay?
I'm only saying
wants
this.
to-
No,
all
no,
he's
no. Is that
expressed.
what you're saying? If I said go, You can represent yourself, sir? You think he's going to be fine?
No, he wants to voice himself, he wants a voice, clearly he wants to defend himself. I'm just saying simply that he came in here just a minute ago and he said he wanted to represent himself and he did not want to be involved. He did not say he did not want to be a part of the proceeding. That's all I'm saying.
All right, bring him out again. Let's see what happens now.
Your Honor, if it, I'd be
Go.
happy to just stand by.
Stand over there.
Or whatever he needs.
Your Honor, with that, he keeps finding ways to communicate to the victim and essentially trying to get her not to testify.
Okay, we'll talk about that later.
Yes, sir.
Mike, do you need to be somewhere else? Or,
I'm just, he's being entertained.
yeah, well, that's not what this courtroom is for. You got something else to do, do it, please, unless you want to represent the man.
No, I'm just.
I know you're enjoying yourself, but this isn't an amusement factory. Come on.
Judge, I believe that how the court's gonna resolve this situation. Judge, without a jury here, I believe you can take whatever measure.
Give me some ideas. Come on up, sir. Here's what I'm going to do, Mr. Harper. He's fired. Is that,
Okay,
that's good? Okay. Are you going to represent yourself,
I'm pretty much probably gonna hire an attorney.
sir?
Probably gonna hire an attorney.
Are you able to hire
I
somebody?
am able to hire.
Who, is there anybody in particular you wanted to talk to?
Probably gonna be out the
Do
city.
you have any
limits.
names or
You
anything?
know, out the city limits, but
How long would it take you to hire someone?
I need a little time, but like,
A week?
need longer than that.
A few days?
3 months.
No, I can't give you that much time, sir. Is there any names you have that you would like?
No,
We
I don't-
might be able
I-
to call them and ask them to,
I don't want nobody in this county. I don't want nobody in Jefferson County. I don't want nobody in the confines of Jefferson County. I don't want nobody out here, period.
how long have you been in jail on this thing?
Like 15 months.
It's too long. Okay. Do you have any thoughts of any names that come to mind that you would,
Well, I don't have no thoughts of name, but I got some ideas. And
Like what?
I got like some people I can probably,
like who? So
talk
we
to
can,
that give me like numbers or
you
names and stuff
need
like
some
that.
tips from
I got
somebody.
tips from people, basically. I'm trying to get somebody from out of town.
All right. How long would that, I can't give you much time. I'll give you a week to figure that out. And then we'll bring you back and see what happens.
About a month or something.
No, see where you are in a week,
But
okay?
to be honest with you, sir, I ain't gonna lie to you. My rights been violated, so I have put in a change of venue. I never heard nothing. I did habeas corpus, 2 of them. I heard from one, haven't heard from the other. I'm actually filing another lawsuit too, because I wasn't able to get on the kiosk at all at one point. And for the grounds of me being segregated, I haven't been through a due process of law, nothing to be put in segregation or be under any restrictions. I wasn't able to do grievance, law library.
Hold
I
on.
wasn't able to do none of this.
You're in my.
I haven't been able to use a phone
You
for
know
7
what-
months.
Do you
Call
know
my
what you're
family.
charged with?
I got 2 sons in jail.
Do you know what
Godson and my real
Hold on,
son.
do you know what
That-
you're
that-
charged
that-
with on all this so you can focus on fighting those allegations? Do you know what you're charged with?
I know.
It says, 1, you violated probation by committing aggravated assault with a deadly weapon. It actually, this all looks like it's on or about the same date, November 21st. All of this is all about November 21st,
Yep, I'm
2023.
innocent to prove
That's
it.
all. This is
But
what
I mean, I'm ready to
everything's
go
all
to trial
about.
for that right now.
Yeah.
We can go to trial for that right now. Let's go. So what am I
Well, this
doing?
is this is a motion to
So
revoke that goes before the
this is what I'm
trial.
saying. I got a case law to tell you, you can't do that neither.
Okay,
I can pull this out and show
all
you.
right.
I
But
can read it to you and tell you
but
case
you
law.
want to go forward with the motion? That's what we can do today.
No, I'm telling you,
When can you be ready for that?
we ain't supposed to go forward with a motion when the paperwork tells you, and the law states that, you see?
Your Honor, Mr. Harper he's on there with his mother admitting that he's using all these different accounts, using different individuals' accounts, even though you ordered him not to communicate with anyone on there.
So.
He's
No,
on
no,
there.
no, let him-
I'm doing that. I'm gonna
Sir,
keep doing it. I'm
sir,
gonna keep doing it, bro.
communicating with
Sir,
I'm gonna keep doing it.
Sir,
Look,
if you
look.
game in the
No
system,
state shall deprive any person of life,
All
liberty,
right,
or
all
property
right.
without due process of
Okay.
law. U.S. Constitution. Come on now, what you talking
No,
about?
don't interrupt people,
Yeah,
please.
no, what he interrupted me for? Hell with him. He interrupted me.
Sir, please follow the rule. Thank you. Are you representing?
I'm not
You wanna
representing
represent-
myself. I'm telling you what you wrong at. Look,
All
hold
right,
on, let me find this.
and it's noted, and you'll get to appeal that. You've made a point, you'll appeal. We're gonna still move forward with the motion to revoke
I'm
probation.
not going forward with a motion to revoke.
You don't have a choice, sir.
I do have a choice.
Yes,
I'm not going
no,
to
you
go
don't.
forward with a motion.
It's a court order.
Not
We're
going
gonna
to,
move
I'm not,
forward.
it's not a, I
On
don't
your
give a damn
terms.
about your
I know,
violation
you
of my rights.
You don't
or
care about the
unlawful court
Constitution.
order.
You don't care about the
Yeah, yeah, I got-
Constitution in your.
Give a fuck about the Constitution.
Yes, sir.
or the fucking stuff you're reading to.
You were so
Get the fuck out of here,
and
man.
you were being called in connection with the cases of Desmond Lorraine Harper in cause numbers 23 CR 580 and 23 41343. Mr. Harper had been here for a scheduled hearing on motions to revoke probation in these two cases, correct? He is on probation. In each case, deferred or unadjudicated probation for illegal possession of controlled substances, namely. It's gotta be something hallucinogenic. I would think the way he acts. Let's see what was. Methamphetamine. And then in 41343 for the second degree felony of aggravated assault family violence. Motions to revoke unadjudicated probation have been filed And he was, by the way, he was placed on probation on August 21st, 2023 in this court. And it is alleged that the defendant Desmond Harper has violated his probations as of motions to revoke probations filed on January 5th, 2024. It is alleged that in each case, he committed the offense of aggravated assault with a deadly weapon. On involving two victims on or about November 21st, 2023 in Jefferson County, Texas, committing the offense of evading arrest or detention November 21st, 2023 in Jefferson County, Texas, and committing the offense of a felon illegally in possession of a firearm on that same day. And the defendant was brought in today for a motion to revoke probation, and needless to say, was violently combative, vulgar, cursing, and abusive to the court, everybody here, and also to his attorney, who he stated he fired and did not want his attorney at all near him. And so Mr. Matuska, as his attorney, was released, as it was obvious that the defendant was threatening violence to everyone, including his attorney, because in the most childish fashion, he had a temper tantrum because the rules state what they say, and he wants his rules, which are disruptive and obviously not coherent to the rules of law and due process. And then he demanded that another lawyer, that he be allowed to find another attorney. And the court noted that unless that happens, we're moving forward. He fired the person who was appointed. He doesn't have anybody else in mind that he wants. And we are going to move forward on these motions to revoke probation. Without him, somebody will be available if he close by will be appointed to represent him in the event he wants to refer to someone, but he expressed his strong feelings that he didn't want anybody that any particular person named. He then aggressively shouted vulgar statements at the court and using vulgar names, and is obviously in a incoherent fashion, was very angry and had to be escorted out of here by several law enforcement officers. Now, what do we do with an obstreperous person like this who wants to control the proceedings and completely ignore all rules of evidence and procedural matters? The court is coming up, trying to think of an idea. We don't have available a cubicle that we can roll in here to keep him isolated from others and from being angry, boisterous, and obstinate and controlling the procedures. It's obvious, we've said enough to him. When he is not getting his way, he screams and shouts vulgarities and is uncontrollable. There is a method of dealing with that. If you don't have a cubicle, he can be gagged so that he does not control the process and he is present, which he's required to be. But with him, when he does not get his way, when the rules of decorum are expressed, or the rules of evidence and the rules of procedure are expressed, he doesn't agree with them. So he screams and shouts and is vulgar to everyone involved. first thing the court is going to order that when he's here, he shall be gagged, so that we can conduct the proceedings. It is built into the system. If somebody can come up with another idea, let me know. But when he is allowed to speak, he screams, shouts, and controls, and you cannot stop it. The tail does not wag the dog. We got to have control in here, and that's, if somebody can come up with another idea, let me know. But we've done this I've been a lawyer for 40 some odd years. And in federal court, we were able to bring in cubicles, but we don't have this available here. And he has a right to be present, but he doesn't have a right to control and put the proceedings in disarray and make a mockery of it. So we can, and he's going, needs to be, there's not a jury here. He can be restrained. He needs to be restrained as well, because he's a violent man. But he's going to be ordered in this courtroom to be restrained and gagged. Also, he is ordered not to have any phone contact from the jail. And I don't know how that's happening, how that's going to get controlled, but it needs to be controlled. He is getting in contact with complainants and witnesses. And the state says they can't control it. The executive branch needs to do that, or else I'm going to find out why that can't be controlled. If an inmate can have the ability to influence cases that have been filed and influence and incite problems with witnesses so that they are unable or unwilling to testify, then the 1787, the Constitution up to now has just been burned and thrown out. That's not the way due process works. But we've got to fix it when we deal with odd situations that are unusual. We're smart enough to figure it out. But he can't control the proceedings. He has a right to be here. So we're going to have him here present where he is restrained and he is not vocal. And he wants to represent himself. Now, I don't know how we're going to do that when he wants to question witnesses if he wants to represent himself, because he becomes vulgar and obnoxious. But he has a right to question witnesses under the Constitution. And that's why we have to, when you're in a cubicle, you can turn the thing off when they get out of hand.
Judge, I don't believe he stated that he wants to represent himself. My memory for what he stated in the earlier proceeding is different.
Right. What it results in, he fired Mr. Matuska for no good reason, but he was violent. He is violent. He was violent and aggressive and threatening to him, which is what he's going to do to, if you open that door, there are 7 billion people on this planet. Many of them are lawyers. Do you see opening the door and a problem? He won't find one, but he certainly would like y'all to keep bringing them around. There's nothing that shows that he wouldn't be the same way to anyone that's appointed to represent him. And he's free to hire somebody, but he's been in custody, since, I don't know when he was arrested here, but he hadn't hired anybody on his own. He's free to do that anytime. And two things. Number one, he doesn't have a time situation or gives us any hints at when he could afford to hire somebody. So I would be subject to appointing someone that he obviously has a plan by his actions he won't like. And so he can be disruptive and there's no end to this. We've got to control the proceedings.
And Your Honor, the only way, my understanding, the only way to prevent the defendant from actually communicating with anybody outside is for the court to order him held in isolation.
All right. The court finds just cause by his actions today and his statements made. And what the officers of the court are telling this court, that he makes, he's able to have people on his behalf make phone calls, which can intimidate and influence witnesses, which disrupts the very heart of due process and the right to a fair trial, which is given to the state as well as to the defense. That he is now controlling this proceedings, which is not what the Constitution was intended for. It was for responsible people to handle it and make sure that it's accomplished, not giving the keys to the candy store to children who just want to eat candy. You've got a witness here you want to put on? Raise your right hand, sir. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Lower your hand. Thank you.
Please state your name for the record.
Matt Gardner,
Mr. Gardner, where do you currently work at?
Jefferson County Sheriff's Office.
And what is your title over there?
I'm the internal affairs investigator as well as the grievance officer for the jail.
And do you have access to the jail calls there as well as the kiosk messages that the inmates communicate with you?
Yes, sir.
And do you have an inmate there, the name of Desmond Harper, and his date of birth being 3/17/1986?
Yes, sir.
And just to be clear, there's two Desmond Harpers currently in the jail.
Yes, sir. The other one is Desmond Harper Jr. I believe that's his son.
But with regard to Desmond Harper Senior, who was in the courtroom earlier, have you, he was ordered not to make any communications by this court, is that correct?
Yes, sir. The court order was given to Captain Bruce Menor. He's over records. And the last date that we saw that he made a phone call from his account was July 31st of last year. So I would assume the order came in that day or the following day.
And has the defendant, has he been able to still communicate with other individuals via the phones and the kiosk there? And even with one of those being the complainant in this case?
He's made a multitude of phone calls using several inmates' accounts.
And how do they do that with the other inmate?
The phone system, the old one would work off of voice recognition, basically saying something to the effect that my voice is my password. The new company we're with that encompasses the kiosk and all of that. They put in their inmate ID number and a PIN number, like if you use an ATM machine, a PIN number. So they're able to share that and sell the information to each other. So if they're on restriction, they can still get around that and use the phone.
So still, even with that order, the way the jail works, those inmates can still manipulate the system there and kind of use the phones with other people.
Yes, sir.
Is there a way to keep him from using the phones or any communication whatsoever?
To keep him from being able to make phone calls or being near a phone that's being used to speak, we would have to shut down day rooms and put him in alone. Or he could be in an isolation cell. They have a separate day room area that's one person at a time, one-on-one with an officer, where he wouldn't be able to use the phone.
So if this court ordered him to be held in isolation, would that prevent him from being able to use the phones like that?
Yes, sir.
All right, the court's going to so order. Can I ask the state to prepare a written order?
Yes.
Stating what the witness sets forth or the necessary conditions so the court can sign it and place him in isolation. Then next, what do we do about handling him in this room under his obstreperous actions and his mindset of controlling all the proceedings and then violently outbursting and ruining the decor of the court and decency?
Judge, one of the spectators that's involved notified me that we did conduct a Zoom hearing last week in a different matter altogether where a defendant was not able to be in court. So I know one of the things that was represented to you that
But what was that?
wasn't possible, but
What was the Zoom hearing about, though?
that had to do with that particular defendant's mental competency. And they arranged his appearance that way
Okay.
because he could not get transferred here. His
All right.
situation was that.
Does
bad.
anybody see any difference between a competency hearing and a motion to revoke unadjudicated probation hearing?
Oh, there's substantial difference.
No, I'm talking about in regards to him being present versus being present via television for something like this. Does anybody? I don't know.
Well, Judge, I was just looking at the law in regards to what was passed down about Zoom hearings after the emergency orders with COVID. We had findings and that was supported and the case law is clear there. I believe that by analogy, the conduct we all witnessed here in the courtroom, that Your Honor could extend that to that situation. He's able to see it, he's able to hear it. He can say whatever he wants to there, we can avoid.
Okay.
Unless it becomes so disruptive that he won't
Well,
even allow people.
we can mute him, I
Then
guess.
I think that's a fix for us, Judge, that I wanted you to consider since we're talking about it and there's.
How do we mute them? How do we mute them from here?
You can do it from your. You're the host. You can mute anyone.
No, how do, this is a general mute button. When I mute, it's going to mute everybody.
No,
right?
if you click on, so
When
like,
it's by Zoom, Judge, you have the ability to mute any participants because we did that during the COVID process, Judge, where you would
Okay,
mute different folks. That
all right.
you had the ability to allow a defense attorney to talk to his client, and that was done through a mute
All
button
right.
as well.
Then what we'll do is we're gonna have another hearing with this defendant. And we will tell him what's going to be done. I will order that he be placed in a isolation cell pending the outcome of this matter to preserve the sanctity of the facts of this case and due process. He has decided by being obstreperous, he's going to control all the proceedings and by nature of his defensiveness and combativeness with authorities, physical combativeness, as well as his violent statements of violence and angry outbursts, which prevent anyone from having a say in the proceedings. We can't even overpower his shouting and cursing and vulgar statements. We got to control that. So he's going to have to be gagged or muted, and we will just hold the proceedings that way and have him gagged and proceed and then Zoom from there in the jail. So he is not a danger to anybody here in court.
The folks are telling me that they can transfer him today and set up the Zoom today if you want to go that far.
Yeah, but he doesn't have a lawyer. What are we going to do about that part? He wants to hire a lawyer, but he had a competent lawyer and he fired one today. But it obviously wasn't built for him to, it opens the door. He could fire people endlessly.
Your Honor, maybe we could revisit this Friday or somewhere soon and have us research, and get with our appellate attorney as well as maybe we time to appoint an attorney or see how we can figure out, the logistics on that.
And what we'll do is we can appoint someone to stand by and represent him, but he doesn't get to pick somebody he wants. He just gets a person who is a competent lawyer. And it's obvious that I'm afraid his statements to Mr. Matuska have ruined that relationship and makes that hard for Mr. Matuska to come back. That would be the logical situation. But again, we're kind of plotting new ground here. And the most important thing is he cannot control the proceedings, which is what happened. And as a consequence, nothing got done. But he is hereby ordered to be placed in an isolation cell since he has figured a way to interfere with the due process with obvious attempts to influence witnesses in this case. And that is inappropriate, and it is obvious that he has refused to honor the request not to do that. So we will make it unavailable for him, whatever it takes in the jail to make that work. we will also try to move this thing. This has been pending. Well, these motions were filed on January 5th of 24. So this thing has been pending, which is apparently working in his best interest for over a year now, which is unacceptable. These motions to revoke need to be resolved quickly and expediently, but it is obvious that our attempts to do that today were met with forceful pushback by the defendant, who is obviously a dangerous and angry person. So we got to work with that. We don't have an isolation booth. We'll put him in the isolation cell, and we can mute him when he starts cursing, so that he doesn't control the proceedings or interrupts. But that's what he did. He interrupted everybody. It's on his own terms, and that convolutes all the law. But the law has options that are available, and a lot of those are open-ended methods that it's up to creative people to figure out. But nobody's ever been able to control it. Humans have always, better thinking humans have always figured it out, and there's no reason why we can't do it in this case. So what, I have him back on Friday? That's what we want to do?
Well, Your Honor, if you just wanted to revisit it on Friday and just.
No, he's not leaving the jail. He's not coming over here.
Oh, yes.
I don't want him to come here.
Yes, sir.
He's
Just on
showing-
Friday, we'll have it. That way we'll have our research done on that and have an answer for you.
Okay, we'll have a hearing of status.
Yes, sir.
And then we may next week need a hearing then, but we're going to do it as soon as we can possibly get it done and practically. But he's going to be put in isolation immediately.
We can do that, sir.
Thank you. Is it good enough for what this court has stated on the record, or do we need something, a court order?
If there's some documentation, you can get.
I don't have one
Appreciate that.
handy, but state prepare one for the court to sign.
Yes, sir. We'll prepare.
Thank you.
Yes, sir.
But until I sign it, I don't think he can be put in isolation, right? Well, it's
We can
better.
go up and do it real.
Can you do it?
Yes, sir.
And come back. I'll wait for you. Thank you. Okay, anything else on this? We are in recess. Thank you. Bring it as soon as you can. I'll sign it and we'll go on to the next problem. Yes, sir. Thank you.
Okay, we call cause numbers 23-41343 and 23-CR580. And the defendant is Desmond Harper, and then there's a new case or two.
For your honor.
Three new cases. Cause numbers 24 CR84, aggravated assault with a deadly weapon, 85, unlawful possession of a firearm by felon, and 24 CR86, aggravated assault with a deadly weapon. So 5 total cases and 3 new cases and 2 motions to revoke probation, correct?
That's correct.
All right. The defendant is, bring the defendant in, please. Thank you. Hey, Mr. Harper, if you'd be so kind, take a seat right over there. Thank you.
Why I'm sitting down for, sir?
Right over there with
I'm
Mr.
saying, why am I sitting down? I'm asking a question.
You don't want to sit down?
No, it ain't. That's not what I'm asking. I put in motions. I gave you petition for release.
Yes, sir.
Because of delay.
Yes, sir.
I'm still doing, I did a speed trial with case law.
All those motions I've reviewed, they are denied.
You can't
We're ready
deny
for
it, sir.
Yes, we can. sir.
No, you can't. They gotta go to Austin.
No,
And
that will be done
no.
after
With case
these
law,
hearings.
with case law,
That would
case
be
law.
done.
No, you not gonna sit up here and tell me that you're gonna violate my motherfucking rights, nigga. I don't give a fuck about that. I don't give a fuck about that. I don't care about that. I don't give a fuck about you, none of y'all. Fuck y'all. Fuck is you talking about? This is my motherfucking life, white boy, you Egyptian pharaoh. Cause this law right here tell you, or federal congressional enactments authorizing or empowering any of the defendants named here to the place detained on parole for no apparent reason at all to cause plaintiff to be detained on the pretext that he might be convicted for the new offense, then seek he will always be in violation. Motherfucker, a parole takes from plaintiff the presumption of innocence and thus violates the 14th Amendment. All right, here, bitch. I'm not doing none of that.
All right.
So give me up out of here, nigga.
You're taking outside.
Yeah, bitch ass nigga.
Go back to the
Fucking
cell.
pharaohs. Fuck y'all.
Go back to the cell.
Fuck you pharaohs. Yeah, give me up out your courtroom, bitch.
Sorry.
Yeah, nigga. You gonna do, nigga?
Just make sure.
You better give me up out here. What you gonna do, nigga?
Make-
Bitch. Yeah.
Make sure that the speaker is on so we can hear. Mr. West, you made sure we took care of competency matters earlier, didn't we?
Your Honor, I was just appointed on this case like 2 days ago, so.
Do you know anything about this?
And I've got all
Yes,
this covered from me and Mr. Boyd to talk. I know about the facts of the case. I know about the details. I spoke to my client a little bit. I know that at one point he was evaluated for competency and was found to be competent at one point. But I mean,
Well, there's a competency evaluation back in December. And we did that because the similar actions, actions that he displayed here in vulgarity, obstinance, anger, and raving lunacy type statements are similar to what we caused Dr. Ed Rapon, licensed psychiatrist, to evaluate the defendant, who submitted a report December 9th, 2024, that states that the defendant is competent to proceed to a resolution of his legal issues. Is there any reason why you feel like we need another report at this time?
Your Honor, due to the fact that he is very uncooperative and not willing to work with us, even when I was talking to him, he's not wanting to move forward with doing anything. He's just ranting. I would argue, I know Dr. Pons found that he's competent, but I would suggest that he's incompetent due to the fact that he is unable to assist his counsel in moving forward with this trial.
Yeah.
Or this hearing and or these trials coming up. So I would request to have him evaluated again, but I'll leave that to the court. The court's had more experience with them than I have. I've just only been on the case 2 days, so I don't have months of experience like y'all have with.
And Your Honor, this is his third or fourth attorney. This is.
It doesn't have anything to do with Mr. West. I understand that.
Your Honor, I just meant, I think it's its way of stalling and keeping this case.
I don't.
He, in the underlying case that he was placed on probation for, he contacted the witness, tried to keep her from testifying. That's why he was given a deferred, because we couldn't get her. He's done the same thing in this case, contacted her from the jail. There's nothing on those jail calls that suggests that he's incompetent in any way. He carries on normal conversations with his mother. He doesn't get his way, and he comes in here and thinks he's going to delay the proceedings, which he has several times now, because he knows we have a hard time getting the complaint.
But once again, I would prefer Dr. Rapon, since this was 6 months ago, Dr. Rapon follow up with an evaluation.
Well, when we won't be able to get the complaint, sometime in the future. And I know,
but once again, if we could have had a hearing, I guess, earlier, but 6 months have gone by. Mr. Boyd, can you pay attention, please? Would you be so kind? Just don't. I mean, that's just like what I just had to deal with him, turning your back to me.
I was looking at Mr. Larry. See, I don't know what to do. I don't know what to do on that.
Well, what we want to do is whatever way we handle it, we want it to be a secure decision that is not reversed. I want to make sure that all the I's are dotted and T's are crossed. What is the problem in having another evaluation at this time? I mean, I think Dr. Rapon could make it happen within 48 hours or so, but But where do you see a problem?
I guess just my idea is that he acts like this every time, the difficulty in then scheduling a,
But I know, but how many times have we, at the end of the day, how many times have we had this motion to revoke probation hearing set for a hearing? Is this the third time?
I think it may be the fourth, where he acted out at least 3 times prior to this and
First for me, so.
that's just what I'm concerned with is that I know we're very busy in here and that it may take, let's say it take another 6 months to get to a hearing because of.
Why would it be? Yeah, I mean, if now he's got our attention, again. Do you remember the dates of the other hearings?
Probably had, if we had evaluation done in December, I would bet January. And maybe February and then March is when we had to have him to solitary, that's not able to speak. He wouldn't be a priority, and I think we would. My try again was getting April. And we did with today because it was sensitive.
I need you to, we need to have dates so she can pick up the record. So I can look at the record of the times. And I'm not showing in this when hearings were held or attempted to be. I see where there were some resettings for a particular date, but there's nothing that shows what happened on those dates here.
The other than the one where we get the memo to the jail.
Well, here's the deal. It is as well is that's the most important thing is what do we do with proceeding with a hearing with him not present in the courtroom? Because his presence in the courtroom is volatile, vulgar, obstinate, angry, and I've remembered this over and over again. So what do we do, Mr. West and Mr. Boyd? Since they have a right to be heard.
I must keep my position that he needs to be evaluated because he's unable to effectively work with anyone, much less me.
What do you say, Mr. Moore?
Your Honor, the Ninth Court of Appeals had a case very similar to this, in which an individual kept trying to delay the proceedings. Again, there's not a jury here. I think that was part of the argument. It's not influencing a jury in any way. If that individual is the individual is given 2 or 3 opportunities to come out to behave himself. He did not. He was then placed in a holding cell where he could hear the proceedings, and it continued from that point on. And the court held that was.
How does he confer with his attorney?
If the attorney needs to ask him.
How does he confer with his attorney? Anybody know?
If the attorney needs to ask questions, the attorney can go and stop the proceedings, go back and ask a question of his client. But if you disrupt the court so that you cannot hold the proceedings, otherwise you're voluntarily absent yourself from the proceedings because you're creating the situation, not the state.
What are the other dates of the hearings? So I can put that on the record.
I have July 31st, 2024, Your Honor.
Okay. Hold on.
Yes, sir.
7/21.
7/31, Your Honor. Yes, sir.
Okay.
And then March 19th, 2025.
Okay.
We had him January.
And those are the 2 that hearings were scheduled where we had it. There were 2 times before where there was announcements, but that was in.
During those announcements, I think he was obstreperous.
Yes, Your
We
Honor.
weren't even on.
Okay.
I want to say that was for January.
Okay. So 7/31 of last year and 3/19 of this year were the 2 hearings for MTRPs.
Yes, Your Honor.
Would you be so kind? Well, those, let me look, we're gonna take a short break. I want to review the transcript on those hearings. And make a record. Of that. We're in short recess. And we now recall several cases. Hold on, Tommy. Don't bring him out. Oh, he's not, okay. We had several cases involving Desmond Harper cause numbers 23-41343. We will be taking up primarily today. The defendant is on probation for aggravated assault, and there is a motion to revoke probation that is pending on that matter. Then in 23 CR 580, he's charged with illegal possession. Well, he's on probation for, in that case as well, for illegal possession of controlled substance. So, and there is a motion to revoke probation in that case as well. So we will be taking up two motions at the same
That's correct,
time.
Your Honor.
Okay. Those two cases, again, cause numbers 41343 and 23 CR 580. Then the defendant has two other pending, correct, that's three other pending cases. 24 CR 84, aggravated assault with a deadly weapon. 24 CR 85, unlawful possession of a firearm by felon. And then finally, 24 CR 86, aggravated assault with a deadly weapon. And the court will note that the defendant has been evaluated by Dr. Ed Grappon twice now in an evaluation dated December 9th of 2024, where the defendant was deemed to be competent to stand trial based upon Dr. Grappon's evaluation. Recently, a few weeks ago, in fact, the defendant was brought forth for a hearing. You have your date we were here on this hearing.
Recently. So would have happened.
6/9, on or about June 9th of 2025, which would have been about a little over 2 weeks ago. The defendant was brought forth and upon being brought forth into the courtroom, reacted violently and vulgarity. Definition of obstreperous is certainly exactly the way the defendant handled himself. He could not be controlled. He was cursing in a loud, raving voice, and the court ordered him to be removed and placed back in the cell, in the holding cell. Strangely enough, shortly thereafter, as this judge was leaving the courtroom and going to the back office, the defendant tried to speak to the court in the most lucid, calm voice, as in Dr. Jekyll and Mr. Hyde. We had just two complete changes of personalities. But the court, in an abundance of caution, felt as though Dr. Grappon, licensed psychiatrist here in Beaumont, should evaluate the defendant once again. And he did on Wednesday, June 11th, examined the defendant, and in his report, which the court is going to mark as Court's Exhibit number 1 in this cause number on this date. He stated that he went to the jail, Jefferson County Correctional Facility, and spoke to the defendant. And Dr. Rapon, in his report, we're calling Court's number 1, Court's Exhibit 1 on this day, noted that he had examined the defendant in December of 2024, last year, and gave the opinion at that time that the defendant was competent to proceed to resolve his legal issues in court. And he noted that since that time, and obviously last week, he reports there was a significant confrontation in the criminal district court in which the defendant was acting in a very inappropriate and unusual fashion. Apparently, according to Dr. Grapon's report, he was demonstrating significant behavioral discontrol and acting out. So at this time, Dr. Grapon writes, I'm going to reassess him to see if it is volitional as opposed to a product of any known mental illness. So he interviewed the defendant once again, and the defendant presented, according to Dr. Grapon at the examination, a calm and controlled fashion. Occasionally became animated when talking about his legal issues, but he was oriented to time, place, and person. He knew what his numerous charges were, including aggravated assault, possession of controlled substance, illegal possession of a firearm. He described how he perceived the legal issues and how they should be dealt with in legal proceedings. It was obvious to Dr. Grapon, based upon his report, that the defendant, in speaking about his legal issues, was opinionated and extremely focused on what he perceives to be some type of violation of his legal or civil rights. He showed no evidence of any unusual effect. He appeared to be clinically depressed. He denied any anxiety when talking about his legal matters. He demonstrated no evidence of psychosis. He referred to his legal proceedings and his self-representation as pro se, and was very negative about prior legal representation. He maintained adequate eye contact with the doctor and spoke in a conversational term. His judgment in almost every area, according to Dr. Grapon's report, was intact. However, he was very determined and possibly has a distorted view of his role in the legal system. His insight is adequate. His intelligence is estimated as low normal. Diagnosis, according to Dr. Grapon, I find no evidence of any current mental illness nor mental disorder in this man, according to Dr. Grapon. He probably has an underlying personality disorder, which to a great extent drives many of his perceptions. But the defendant, Desmond Harper, is competent to proceed to a resolution of his legal issues. He definitely believes he is being mistreated by the legal system. This opinion, according to Dr. Rapon, is not based upon psychosis, but rather is based upon the way the defendant perceives his involvement in the legal proceedings. He does have the ability to conform his behavior to acceptable standards in a court of law, but only if he chooses to do so. However, given how he perceives his legal setting, it is unlikely that the defendant is going to be anything but difficult. Again, that will be based upon his volitional choice, not driven by any diagnosable mental illness. His recent described and evidenced behavioral discontrol is, in Dr. Grapon's opinion, volition. By that, he states, I mean, he can control this if he chooses to do so. From a mental health standpoint, this man could not appear as he does during this examination and then lose that ability once he crosses the threshold of the courtroom door, unless it represents actions that he chooses to engage in because of his beliefs, opinions, and ideas. In other words, by his choice. Desmond Harper is not in need of psychiatric inpatient treatment intervention and seems to function quite well outside the courtroom setting. Okay, that is the substance of Dr. Grapon's most recent report, which reaffirms his earlier report in December of 2024 that the defendant is competent and he acts in his own volition and his outbursts are his choosing and on his volition, not a product of mental illness. So first thing we're going to do is bring him out and in a moment and see if he can control his manifestations and his order of being decent and contrite and also respectful to the proceedings that go on here. John West, licensed attorney at law, has been appointed to be standby counsel if Mr. Harper wishes to confer with Mr. West. The history, though, from the last meeting that we had, the defendant refuses any assistance and rudely makes outbursts to anyone who wants to attempt to assist him in any way. So we're going to see if he is going to control himself and act decent in this courtroom, or as Dr. Grapon has stated, will, by his own volition, decide to make outbursts and refuse to participate in a decent, orderly fashion, which would then result in him being escorted out of the courtroom back into a cell where there is a speaker so that he can hear the proceedings. Just an overview of what I expect is going to happen here is that the defendant, who the court can at this point hear him shouting, making outbursts from outside the court in the cell, adjoining cell. It is set law that judges are obligated to use judicial power to prevent disruptions and maintain order and decorum, especially in the courtroom. This involves acting in a firm but restrained manner. Judges have the authority to manage their courtrooms and ensure order and decorum, not only for the participants, but for the general public who have a vested interest in seeing and witnessing and viewing proceedings in an open manner. In dealing with disruptive behavior, judges can remove disruptive defendants from the courtroom if their behavior prevents the proceeding from moving forward in an orderly fashion. Judges can also use contempt of court, which may result in a fine or jail time. In some cases, binding and gagging may be constitutionally permissible to keep a disruptive defendant present in the courtroom. However, the judicial decisions are pretty uniform in dealing with these kinds of matters. Removing a defendant from the courtroom is generally preferred over restraining defendants. Now, the removed defendant should typically remain in the court building and be given opportunities to hear the proceedings and communicate with an attorney at reasonable intervals if they wish and request. They shall also be offered the chance to return back in the courtroom if they agree to behave properly. If a defendant who represents themselves, like this defendant who insists on pro se representation, but has an attorney available here in the courtroom to consult with if he wishes. If a defendant continues to be disruptive, the court may, after warnings, require them to be represented by an attorney, whether they like it or not. Judges are expected to perform their duties impartially and diligently, and ensure order and decorum. The least severe sanctions necessary to correct behavior and prevent future incidents should ordinarily be considered and imposed. All right, those are the guidelines that are used under the rule of law in dealing with obstreperous or unruly defendants like this one has been in the past, and who is expected not to change. But we know from his more than one evaluations with Dr. Rapad, he is more than capable of acting rationally and decently. And under Dr. Rapad's analysis, it's his volition. If he wants to act rudely and wildly, that's his choice. It's not because of any type of mental illness. We have in both of these cases motions to revoke unadjudicated probation. And are the parties, is the state ready to proceed in this?
Yes, Your Honor, the state's ready.
All right, and Mr. West, you're on standby counsel. You were prepared if necessary.
And yes, Your Honor, whatever the court needs me to do, whether I'm standby or taking a lead, I'm ready.
I expect from what we've heard, he'll come out and make a scene. That's what he is hinting at. Yes, in the back there. Then I will warn him as best we can and then escort him out. If that has to happen, he'll be placed in the cell. He will listen to the proceedings. And from time to time, I'm going to ask you to be close by there. He'll in the hallway, if you don't mind, waiting to, if he wants to get any advice from you, you're right there to be able to speak with him.
Do you want me to, during the proceedings, be in the back?
Yeah, I think that would be
Whatever the court thinks is best.
the better, because you're standby and not being active at this point in time.
Okay.
But if he wants to talk to you, you're right
I'll be
there.
there.
But all right. So at this time, the court's going to mute because the last time we brought Mr. Harper out, he went into a raging monologue of vulgarities that decent humans don't need to hear. And I'm not going to subject the general public to this, so we're going to mute at the time. Stand by. All right. There is a motion to revoke unadjudicated probation. And Mr. West, I'm going to ask you if you'd be so kind to do your best to
I'll be available
be
for him if he needs me, Your Honor.
available next to him, close to him.
I will say
And if he needs to, if he needs, it's fine. All right, and the defendant is now banging on the door loudly, banging on the cell door to obviously attempt to disrupt proceedings. All right. There are two motions to revoke unadjudicated probation. And the court is going to read this into the record. Each of these similarly state that on August 21st, 2023, that in each of these cases, he was placed on 10 years deferred or unadjudicated probation for aggravated assault, a second-degree felony in 41343, and for the second-degree felony of illegal possession of a controlled substance in which was methamphetamine in cause number 0580. The court is going to proceed. Which allegation does the state want to move on first here? This aggravated assault with a deadly weapon or evading
Yeah, they're
arrest?
all kind of out of the same incident, Your Honor, the same date,
Right.
so.
Allegation one in each case states that the defendant committed the offense of aggravated assault with a deadly weapon on or about November 21st, 2023. And I don't understand this, but it's 1 and 2 are worded exactly the same. How's there a difference?
Your Honor, there was 3 different individuals in the house at the time, so 2 of them had a gun pointed at them, so there was a different victim for each the aggravated assault there.
And allegations 3 and 4 state that the defendant committed the offense of evading arrest or detention in Jefferson County, Texas, on or about November 21st, 2023. And committed the offense in number 4 as being a felon in possession of a firearm on or about November 21st, 2023 in Jefferson County, Texas. The court is going to enter pleas of untruth on behalf of the defendant. The court will also note that the defendant has been banging loudly on the door where it is obviously an attempt by him to obstruct all these proceedings. He is shouting loudly, banging on the steel doors, and we are going to continue as best we can while the defendant, in spite of obnoxious behavior and overt attempts to disrupt and keep justice from moving forward by the defendant, is being performed. All right, Dave, go forward.
Your Honor, the state would call Zachary Moss.
Zachary Moss, come forward. Where are they?
They're right outside.
Raise your right hand. Do you solemnly swear or affirm any statements you make will be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat. Please note that the defendant is banging on the door and shouting, attempting to disrupt the proceedings. Please do your best to move forward, focus, and we will not let obnoxious, obstreperous behavior by the defendant disrupt what is so important under the Constitution, and that is justice. Go ahead.
Please state your name for the record.
Zachary. Yes.
And how you spell your name?
Swear or affirm any statement you make today will be the truth, the whole truth, and nothing but the truth, so help you God. Lower your hand. Go ahead. In spite of the defendant is shouting vulgarities, please just focus and continue. That's what the record show is obviously attempts to try to prevent the court from moving forward in a proper way. Go ahead.
And Mr. Moss, where do you currently work at? And how long you been there at Beaumont PD?
About 2 days.
And are you a certified peace officer?
I am.
Okay. And were you working on the date of Tuesday, November 21st, 2023 at approximately 11:41 a.m.? Yeah. And were you dispatched out to a 3150 West Cardinal Drive, apartment 231 here in Beaumont? That's in Jefferson County, Texas?
Yes.
And what was that in reference to?
I was a student service.
And when you got there at 3150 West Cardinal Drive, what did you observe?
As I was getting to the area, officers advised that they had a subject running from them. So I never went to the apartment upon my arrival. I was just in the area looking for a subject.
Okay. And were you given a description of the individual who was running from the officers? And what was the description?
A blue, white, and black shirt over blue, white, and black shorts.
And did you locate an individual matching that description in that area?
I did.
Okay. And what did you do when you observed that individual?
Upon observing that individual, I activated my patrol unit, spread the lights, at which time he looked at me, he from me, out, and gave chase through.
Well, were you telling that individual anything while you were chasing him?
Yes, also stop and get on credit.
Okay. And did you have your your Beaumont PD uniform on that day? And you were in your marked patrol unit? And you were given this individual lawful commands to stop as you were chasing him?
Yes.
Okay. And did he stop?
No.
Okay. Were you ultimately able to catch up with him and apprehend him along with Officer Jasso?
Yeah.
And was all of this captured on your body cam?
It was.
Okay. And I hand you what's been marked as State's Exhibit number 1. Recognize it? And what is that?
That's gonna be driving like in the unit.
And have you listened to and watched this recording for court today? Was this prepared on a device capable of making an accurate recording of the audio and visual information?
Yes.
Was the operator competent to operate the device?
Yes.
And is this recording an accurate copy of the conversation statements as well as the things that occurred while videoing that?
It is.
Okay. Your Honor, I'd offer what's been marked as State's Exhibit 1. No objections to be played.
It's admitted.
Officer Moss, is this initial portion where you're driving to that location? Jefferson County. And your body cam shows you kind of driving around for a little bit, searching for that individual?
Yes.
And Your Honor, if the court doesn't mind, I'd fast forward it to
Go
the
ahead.
part where he's actually chasing.
Yes, thank you.
That's fine.
And was that a kind of a concerned citizen there that was giving you all some information? Yeah. And did the individual did you ultimately identify the individual right here that you were able to take? Yes. And who was that?
He was later identified as Desmond.
And what's his date of birth?
3/17 of 1986, be March 17.
And that individual, so Desmond Harper, what did he say to the concerned citizen there that saw what was going on?
He said he quit snitching, and quit telling, and then told him to be safe.
So was that, did you take that as a threat to that individual who was coming up and trying to? Was Mr. Harper very agitated once y'all caught him?
He was just.
And eventually, after a while, after he's sitting there, was he able to calm down and talk normally to you?
Once he was put in the car, I never had any more contact with him, but up until that point, now, I think it's kind of.
Officer, if you'd be so kind, would you be so kind to step down, peek into the holding cell? I'm going to ask you if you recognize the defendant in this case as the person who you arrested on that occasion.
Yeah.
Go ahead, Steve. Go ahead.
Officer Moss, was that individual ultimately arrested for and Officer Moss, the individual that you just were able to observe in the holding cell there, is that the same Desmond Harper that you placed into custody on the date of the offense? And what was he, did you ultimately arrest him? Was he ultimately arrested that day?
He was, yes.
Was that for evading arrest or detention
It was.
as well as other offenses? I would pass the witness, Your Honor.
Ask Mr. West if he'd be so kind, if he wants to, if there's any questions he may want to ask on the defendant's behalf from cross-examination.
He's gonna ask the judge.
Questions you'd like to ask, after you back? Okay, I will have you take it.
Yeah, I tried to speak with the defendant a moment ago. He told me and just like before things for me to go do to myself. So no, I don't think he has any
He's
questions.
speaking vulgar to you.
Yes, very vulgar. I asked him if there's anything he'd like to ask. I can ask on his behalf or do, and he told me to do some stuff. So
He's in there listening to these proceedings.
Yes,
The proceedings
yes.
are being.
Okay. But I'll.
Any cross-examination, as you're listening to the proceedings too, is there anything?
I cannot hear. He is continuously yelling and banging, so I have not heard any of the testimony because he's made it impossible to hear. I don't think he's even been able to hear what's going on because he's constantly trying to
By his own volition.
drown out the proceedings. Yes, so I don't even know what's been asked, so I cannot not ask the questions because he's made it impossible.
You can certainly be in here or there, whatever you feel like is best to help him under his circumstances that he's putting himself into.
Well, in this case, Your Honor, if I was obviously representing him, I'd be here listening to the questions, but I'm just here as a standby, so I'm not, in a position to take lead or to
He's aware.
strategize.
You
So
were ready, willing, and able to.
I told him as soon as I went back there that I'm going to be sitting there. He has ask for me. I'll be right there and I'll be listening. But we ain't one able.
All right. Oh. Anything else?
No, Your Honor, and I'd ask that Officer Moss be excused. He's been up since he worked the night shift, so.
All right. You are excused, sir. Thank you for bearing with us. This is an unusual situation and thank you for being dignified and professional. Next. Next. Come forward. You're calling another witness?
Yes, Your Honor.
Come forward, sir. Thank you for bearing with us.
The Officer Michael McBride.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. The defendant is in the cell and is strenuous, is attempting all he can to disrupt the proceedings and prevent his hearing from occurring. And please bear with us and act professionally like I know you will. And with your reputation. Go ahead, sir.
Please state your name for the record.
Name's Michael McBride,
And where do you currently work at?
the Beaumont Police Department.
And how long you been working there, Officer McBride?
I worked the Beaumont Police Department since January of 1996.
Okay. And were you working there on the date of November 21st, 2023?
Yes,
And at approximately 11:40 a.m., were you dispatched to a 3150 West Cardinal Drive, apartment 231 here in Jefferson County?
yes, sir, I was.
And what was that in reference to?
Reference to disturbance,
And
Hey, go ahead.
when you arrived there on scene, what did you see when you got there?
Before I arrived, we had another officer that advised that black male wearing black and blue shorts, matching black and blue shorts, that fled across 4th Street towards Church, the 45 block area.
And were y'all ultimately able to apprehend that individual?
Yes, sir, we were.
And was he identified?
Yes, sir, he was.
And who was that individual that was arrested that day?
Desmond Harper.
And Your Honor, would you have?
Yeah.
I would add that you look at the individual in the holding cell back there and see if that is the same individual that you
Thank you.
recognize from that. And Officer McBride, is that the same Desmond Harper there in the holding cell that was apprehended on the date of November 21st, 2023?
Yes, sir, it is.
And was he arrested for evading arrest as well as aggravated assault with a deadly weapon
Yes, sir, he was.
and felon in possession of a firearm as well?
Yes,
Were those events captioned on a small portion of your body cam there, I guess, towards the end of the arrest?
yes, sir, I believe more than what I've reviewed just while ago.
Yes.
Okay. Yeah, yes, sir. After getting apprehended, we took him back to the complex, speaking to victims. trying to get him out of one vehicle, put him in another vehicle. I was just talking to him, trying to get him to move peacefully, without trouble.
I'll show you what's been marked as state exhibit number 2. Do you recognize it?
I wouldn't recognize that, but I can submit that, but,
Did you, okay, well, were you able to review your video?
I reviewed a short video of my concern.
Right. And that was the same, the one that tagged here?
Yeah, I didn't see the tag, but I watched the video, I'll tell you, yes.
Well, on the video, were you able to,
If you show the video, it's like a photograph. Is
Yes,
that
sir.
true and accurate
The
representation?
video I saw earlier was my video of that day. Just
that's true and accurate representation, I guess, that took place.
a short portion after he was apprehended, he tried to get him from one vehicle to another.
And with that, with Mr. Harper, initially, was he very aggressive, loud, and cursing everyone?
Yes, sir, he was.
At the end of the video, was he actually calmed down and able to talk to you pretty
Yes.
rapidly?
Yes, I was trying to explain to him the consequences of not moving from one vehicle to the other, the missing transportation. He listened to reason. No, if you got the other vehicle, they got struck. Yes, sir.
So did it seem as though he could comprehend everything you were saying as well as hold a intelligent conversation with you?
Yes, sir. Yeah, at the end there, yes, sir.
Initially, it just seemed like he
was just
very angry.
He was trying to get away from us, yes, sir, absolutely.
And when he didn't get his way, he was angry and then finally calmed down over the issue.
Yes.
And it's, you're on out past the witness.
Your intent on this witness was what now?
Essentially honored to establish the, that Mr. Harper is, he becomes very angry when he doesn't get his way or when he's doing, a situation, but he does have the ability to calm down, to rationally talk to individuals, that he's not, incompetent or in any way.
So you're not using this witness for the presentment of the elements of aggravated assault or evading arrest or a felon in possession of a firearm?
That's correct, Your Honor.
Okay. All right, ask John West if he has any questions he would like to ask on the defendant's behalf. Thank you. All right, Mr. West, on behalf of the defendant, are there any questions that he may want you to ask on his
Again.
behalf to this witness?
Again, Your Honor, he has consistently made noise and been banging the whole time, so I don't believe he's even heard what's been said because I think he's trying to avoid.
He's attempting to try to prevent himself. He's doing what he can to appear to make it appear that he cannot hear the proceedings by his own actions of disturbance.
Well, it is making it impossible for me to hear, so I know it's working, but I
Please
can't.
stand by if he, and
I'm
keep
still.
reminding him every time, constantly that you can, if he wants you to help him in any way, let us know, representation or advice or being his attorney.
Yeah.
We can change quickly if he wishes. Anything else?
No, Your Honor.
This man can be excused. Thank you, sir. Next, please.
Thank you, Your Honor.
I'll call Carolyn Lewis, Your Honor, as they would call Carolyn Lewis.
Hey, can you do something? I was supposed to have my order. I was supposed to, they sell it for the nationwide. I'm stuck in this, I was waiting. And so, can I, call this, you can call this loading. And is there another time later this afternoon? Please raise your right hand. You solemnly swear or affirm any statements you're going to make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God. Please have a seat. Thank you. And the defendant is in the holding cell because he is refusing to act decently and proper. And the have given him all opportunities and all he does, you will hear, do your best to focus. He'll bang on the doors and try to disrupt these proceedings. But it's important that he's close by because this is his life and we're trying to accommodate the Constitution along with his disruptive behavior, but he will make outbursts and it's vulgar. There's a lot of vulgarity. Please bear with us. And you seem like a nice lady, but thank you for bearing with us. Go ahead.
Please state your name for the record.
Carolyn Lewis,
Hey, Miss Lewis, where do you currently work at?
Belmont Police Department 911 Center,
And how long you been working there at Beaumont PD?
32 years.
All right. And how does that system work there? When an individual calls 911, how does that work? Is it then recorded there at the Beaumont PD?
Yes, sir. When you call into our office, the lines are actually recording before we actually pick up. So you have a pre-recording of Beaumont Police Department, Beaumont 911, where is your emergency? But it's actually recording the caller's information.
And is that system then uploaded to, I guess, a hard drive there or,
Yes, sir.
and, with that, who has access to that? Is it,
The shift supervisors and myself.
okay. So it's very limited who has access to that and be able to, get that information?
Yes.
And are those phone calls, are you able to, in any way edit those phone calls or,
No.
manipulate them? Okay.
No, sir.
So essentially, you're able to, they call to receive, they're uploaded to hard drive, then you're able to download those from the system and provide those to the law enforcement officers to get to
Yes,
then.
and each has their own username and password.
Okay. So it's password protected and makes it much more difficult for someone to in any way, or limit to has access to that as well as prevent anyone else who shouldn't have access from getting access. Was there a call made, like 2 calls made on November 21st, 2023? There it is. And what was that? Do you know what that was in reference to?
It was in reference to, if I'm not mistaken, a disturbance. Gentleman had a weapon.
And one of those individuals on there, Dana Rito.
Yes.
Okay, another one of the callers. As well as, are you able to identify the individuals who call in there at Beaumont 911? Yes. And does it also collect the phone numbers there?
Yes, it does.
Okay. Now, so essentially you have access to all those records there, the digital records that are uploaded to 911 there?
Yes, sir. I do.
And are they kept in the regular course of business there at Beaumont PD?
Yes.
And it's the regular practice of Beaumont PD to make those recordings?
That's correct.
What is that going to show me on this here? What is this exhibit going to show?
Yeah,
You're
these
about
are
to move to introduce.
911 calls from the day of the incident.
What's that? How does that prove one of the elements of each? Because all we have are 3 crimes, right?
Yes, Your Honor.
Okay.
They're actually discussing the gun on the 911 call and that there's what's going on with him pulling a gun on another individual while his mother.
Do we have people though who are going to support that? We have individuals to support that?
Yes, Your Honor.
Okay, why don't we call them? Aren't they the best witnesses? I don't know, it's not to tell you what to do, but I mean, we're doing our best because we've got the raving and shouting and vulgarity from a few feet away. And maybe we can go through this.
Yeah.
He's already authenticated.
Why tender what marked as state's exhibit number 2, 911 calls. It's done. And
All right, the court will admit it. And that is the item that is a true and accurate representation of what is being placed on that item.
Yes, sir.
The statements of a party calling in.
Yes, sir. That's correct.
Go ahead. I find this witness is a custodian of records under the rule of law and is familiar with the way the records are, and it is admitted.
I'd pass the witness, Your Honor.
Thank you. And next witness, please. Thank you, ma'am.
You're welcome. Have a good night.
Yes, ma'am.
Yeah.
Please come forward. Come forward. You raise your right hand. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please have a seat right there, man. Thank you. Okay, go ahead. Thank you.
Please state your name for the record.
Delaney Iver.
And Miss Adelberg, do you know an individual by the name of Desmond Harper?
Yes, I do.
And how do you know Desmond Harper?
Married to him.
Okay. And are y'all still together?
No.
Okay. And were y'all together on November 21st, 2023?
Yes.
And where were y'all at on that date? Where were y'all staying at?
In his sister's place,
Okay.
Kansas, George.
Okay. Now, is that where y'all normally stayed?
For that moment, yes.
Okay, just for that moment. But as far as okay, on that date, how did that start off that morning?
Well, hold on. What are we talking about? Where is this located?
At the 31, Miss Adelberg, was that at the 3150 West Cardinal Drive, apartment 231 in Beaumont?
Yes.
And that's Jefferson County, Texas?
Yes.
And that was Mr. Harper's sister's residence?
Yes.
And what was her name?
Kansas, George.
Okay. And how did that morning start off with you?
We woke up, got dressed, and he had to go to probation that morning. So
Hold on, who's he?
Desmond.
Thank you.
And he had to go to probation, so we got dressed and started on our way to the probation office. And as we was riding, I'm looking out the window and he started telling me that I'm looking at him and walking down the street, he had stabbed me in my eyes.
So, if I'm correct, so Mr. Harper thought you were looking at another man and he told you he would stab you in the eye?
Yes.
Okay. And that was that on the way back from the probation office when you?
On the way to the probation.
Okay, so you rode with him to his probation visit when he went there. What did y'all do after y'all left the probation office?
We went straight back to his sister's apartment.
And what happened when you got there to the apartment?
I went straight to her couch because she was sitting there and his cousin was also sitting there, and I told her, because at that time I was scared, I told her that I was not leaving with her brother. And that I was scared.
And who did you tell that to?
Kendra George.
Okay. And what happened when you told her that?
She didn't say anything. I sat there and we sat there. And I told her that what he had just told me inside the car. And so I just sat down.
So were you afraid to go anywhere with him after that?
Yes.
Does Desmond have a temper?
Yes.
Does he get angry really quickly?
Yes, he does, but I really don't have yes, he does something.
Well, now he's on probation for aggravated assault as well, right?
Yes.
And what was that from assaulting you with a I believe it was it a golf club?
A bat.
A bat, yeah. It was assaulted you with a bat previously, is that correct?
Yes.
So you're afraid of him and you say that you don't want to leave with him. You tell that to his sister. What does he do at that point?
Beg him and his family member, Antoinette Reed, started to argue.
Okay. So there was another, just to clarify, the individuals at the home were yourself,
Yes.
Desmond Harper,
Yes.
Kendra George, who is his sister,
Yes.
and then Antoinette Breed.
Yes.
That is that Desmond Harper's cousin?
Cousin.
So all four of you are there in the apartment at this time. Okay. So did he attempt to get you to leave with them? Did Mr. Harper?
After they started arguing, yes, he took me to get to leave with him, but I was scared.
And did Miss Miss Breed then attempt to essentially throw herself on you to kind of protect you?
It was his sister.
So Miss
on top of me because to protect me because yeah.
So Miss George threw herself on top of you.
Yes.
Okay. And when she did this, what happened?
She was just on top of me and I guess he the gun. This was I had my head to the floor by this time, but the gun, that's when the gun came like.
Okay. So did Mr. Harper pull out a gun at that point?
I think he ran upstairs and went to go get it.
Okay. But at some point during this, while the arguing's going on, he goes and gets a gun?
Yes.
What color was that gun?
Black.
Was it a handgun or a shotgun or what was it?
A handgun.
Okay. And did he point that handgun at both yourself and his sister?
Yes.
Okay. And did he say anything while he was pointing the gun?
No, I do not remember that part. Well, I remember he said in the back of the gun took out my head.
So he put the gun to the back of your head, and also did he point it at his sister?
Hold on. Okay, the defendant was nodding
Yes.
when you were asking about
Obviously.
putting it in the back of the head, which the record shall show, but
Yes.
if you'd be so kind to, it's hard for us to take down nodding or shaking. You have to speak so that the record will show what you mean. Thank you for helping us. Thank you, ma'am. Go ahead.
And so he put that, just for the record, he put that gun to the back of your head. Is that correct?
Yeah.
Okay. And he also pointed the gun at his sister, Kendra George?
Yeah.
Okay. Did Kendra or Antoinette, did they call Dana Rito during the middle of this?
Oh.
Or are you aware of if they called her?
Dana Rita, yes.
And
Reed called Dana.
and who's Dana Rito?
His mother.
Okay, and you say is that Desmond Harper's mother?
Desmond Harper.
Okay. So did they also call 911?
Yes, his sister Kendra George called.
Okay. And while y'all were there, was Desmond still there with the gun?
Yes.
Did the police show up?
Yes.
And what happened when the police showed up?
He ran out. My face was still into the floor, but I heard him run out the back door.
And were y'all ultimately able to see that he left the gun on the kitchen table there?
Yes.
Okay. And was that found by the officers?
Yes.
And did they then confiscate that weapon and take that with them for
Yes.
evidence?
Yeah.
Okay. And why didn't you want to leave with Desmond?
Because I'm afraid of him because he is abusive.
And had he assaulted you prior to this?
Yes,
Is that few times or many times?
many times.
And that was with his fist and with objects, or what was
With
it?
this fist and the last time before this incident was with the bag.
Were you afraid that he would potentially kill you?
Yeah.
And Your Honor, I guess if we could ask if she can identify the defendant in the cell.
Okay. Okay. We're gonna ask you if you be so kind, bailiff is going to escort you, and if you can look in the cell, and we're gonna ask you if that is the person you know, the defendant Desmond Lorraine Harper. Thank you.
Go ahead. And Miss Adelberg, were you able to see the individual in the holding cell back there? And who was that individual?
Desmond Harper.
That the same Desmond Harper we've been talking about?
Yes.
Okay, that pulled the gun on you and
Yes.
pointed it to your head?
Yes.
Your Honor, I would ask that the record reflect that the witness identified the defendant.
Yes, it will.
I passed the witness, Your Honor.
All right. And if John West has any questions on behalf of the defendant. Mr. West, any questions you wish to ask of this lady?
None from me, Your Honor. I regret to talk to talk to Mr. Harper. He actually did listen this time to these questions, and still does not want to ask any questions, refuses to tell me anything. So,
All right. Then you are excused, ma'am. Thank you. Next, please.
Your Honor, and if we could have about 3 or 4 minutes, we have an officer coming over there, very busy, and thought you'd be happy with these other witnesses. Statement called Lindsay Rose.
Raise your right hand, please. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Let's have a seat. Thank you. Go ahead.
Please state your name for the record.
Lindsay Bro,
And Miss Rowe, where do you currently work at?
the Belmont Police Department.
Okay. And y'all been very busy over there, right?
Yes, sir.
Kind of explains the dress there, and y'all been having to get your hands dirty today.
Yes, sir.
Okay. And what do you do over there at Beaumont PD?
I work in the crime scene unit.
Okay. And so what are your duties as working there in the crime scene unit?
Our main duty is crime scene whenever the office calls out. But we have a wide variety of duties back in the office as well, but evidence and some of those.
And were you working there on November 21st, 2023?
Yes, sir.
And were you called out to a 3150 West Cardinal Drive, apartment 231 here in Jefferson County, Texas?
Yes, sir.
And what was that in reference to?
Very
If it helps you remember, go ahead.
Putting our report was an aggravated assault.
And when you got there on scene, were you, did you photograph anything?
Yes, sir.
And what did you photograph? Okay. And where did you, did someone hand you that firearm, or did you locate that firearm, or was
Yes.
And was that, who was the officer there that?
Officer Wilson.
And is that the firearm he had collected from the house there?
I believe so, but I was not there for that.
And essentially you're there on scene, there from the house, and he had a firearm that he needed you to essentially to photograph and to place into evidence?
Yes, sir.
Okay. And do you recall, what kind of gun was it?
A Taurus G2C 9mm.
Okay. And what was that serial number ACG 976118?
Yes, sir.
Okay. And did it have a magazine in the gun?
I don't recall if it was in the gun, but it was with this.
And did the magazine have bullets with it?
Yes, sir.
Okay. And I show you what's marked as state exhibits 206. Do you recognize those items?
Recognize those photos? Well, they weren't, it was I think actually to be referred to two, so just for clarification of the record, Your Honor, there's only been one exhibit that's been actually asked to be admitted to the record, and that's state's exhibit number 1. State's exhibit 2 was initially offered, but we did not offer that in evidence.
What was it for the record?
That was state exhibit 2 with a body cam video from, I believe, Oscar McBride.
And the record just shows that the witness is reviewing the exhibits, and those are state's exhibits.
2 through 6, Your Honor.
Okay.
And do you recognize these photos?
Yes, sir.
And what are they?
They're photos of the firearm and evidence.
And are they a true and accurate representation of the firearm and those projectiles as you photographed them on that date?
Yes, sir.
Did you then place those into evidence at Beaumont PD after you collected these?
The following day, I did.
Your Honor, I'd offer state's exhibits 2 through 6.
You would be so kind to the formality of going to show it to Mr. West on behalf of the defendant, see if they want to say anything about those exhibits. Thank you. 2 through 6 has been tendered. Mr. West, you've had a chance to review them. Is there anything you'd like to add or say from those?
No, Your Honor, I showed them to Mr. Harper. He told me to take them back to the courtroom.
Okay.
So
They're admitted without objection.
And Ms. Blow, can you explain the uniqueness of a serial number on a firearm there?
They are unique to each firearm.
So no 2 firearms have the same serial number?
No.
Okay. Now, the penal code defines firearm as any device designed, made, or adapted to expel a projectile through a barrel by using energy generated by an explosion or burning substance or any device readily convertible to that use. Was this gun here, is that a firearm?
Yes, sir.
Okay, and that was capable and able to designed and made to expel a projectile. And in fact, it had projectiles that were in a magazine there with it. And also, we have deadly weapon defined as a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything in the manner of its use or intended use is capable of causing death or serious bodily injury. The firearm that's in those states exhibits 2 through 6 that you collected there, is that capable of causing serious bodily injury or death if it's in the manner of its use or intended use? And is it manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury? I pass the witness, Your Honor.
Yes, sir. Thank you, Tom. May I ask Mr. West, which is to ask this witness any questions on behalf of the defendant?
I tried to ask him, he again would not give me any questions to come back. He said that he wanted to come back out now. He did say that, so, but I just relay what he said.
Okay. Anything else? Open this witness?
No, Your Honor.
You're excused, ma'am. Thank you. Next, please.
The state arrest, Your Honor.
Summary. Someone.
Your Honor, the defendant placed on probation on August 21st, 2023 for aggravated assault, family violence, 2nd degree, as well as possession of controlled substance, 2nd degree felony. And the only reason why the state had agreed to be deferred on that was because this individual had scared the witness and intimidated her. The same individual that he had beat with a bat, Delaney Adelberg. And now here he is again while on probation, taking a gun, pointing it at her head, as well as his sister's head. And then when the police show up, he flees from the police after they order him to stop and are chasing him. He continues to flee, committing the evading arrest as well as pulling out the gun and committing the aggravated assault after he had already threatened earlier in the day, after going to probation, to stab the victim, Delaney Adelbert, in the eye because they thought she looked at another individual. We're able to see his anger, his outburst, and then going back down to a calm level. He gets angry very quickly, and he was given a huge chance the first time. And the state believes that he deserved nothing less than the 20 years on each of these probation. On the aggravated assault, family violence, as well as, which is cause number F23 41343, as well as cause number 23 DCCR 0580, possession of a controlled substance, which was a second degree felony. He's a dangerous individual. He's going to continue to present a danger to this victim and the community if he's not taken off the street and sentenced to, I believe, the maximum on this, what he deserves.
One of the allegations in each of these indictments similarly allege allegations 1 and 2 in the motions to revoke probation that the defendant violated the terms of probation by committing the offense of aggravated assault with a deadly weapon on or about November 21st, 2023 in Jefferson County, Texas. Allegations 1 and 2 are worded word for word the same way. And for the record, if you'd be so kind to just delineate for the record how those are separate and not the same.
Yes, Your Honor. The 24 DCC R0084 is where Mr. Harper had pointed the firearm at Miss Delaney Adelbert, and that's where she is named in the indictment on that. And 24 DCCR 0086 is dealing with the complainant being Kendra George, his sister, who he also pointed the firearm at while she was trying to protect the complainant, Delaney Adelbert.
Okay. Those are two separate victims.
That's correct.
As you intend, allegations 1 and 2, the defendant committed aggravated assault with a deadly weapon on November 21st, 2023 in Jefferson County, Texas. That's how they're separated and unique from each other.
Yes, Your Honor, that's correct.
Okay. Next. Then the evading, number 3 in each motion alleges he committed the offense of evading arrest or detention with of an officer. Any summary on that?
Yes, Your Honor. I believe the testimony as well as the body cam from Officer Zachary Moss, where he pulled up, he saw Mr. Harper, described what he was wearing. He had a description of that. He saw the individual, Mr. Harper, wearing that description of an individual who just fled from the home, who had pulled a firearm on Miss Adelbert and Kendra George. He got out, and I believe what he exactly said was get down with he had his Beaumont PD uniform on, as well as his lights on in the vehicle, and it's giving him a lawful order at that time to either detain him or arrest him at that point. And Mr. Harper then flees on foot and continues to flee, looking back at Officer Moss as he's running, and actually escapes for a short while he's still in view of Officer Moss. And it's like Officer Jasso there was able to catch him as well, and they were able to both take him into custody at that time.
All of that is clearly represented in the video that was introduced and admitted as State's Exhibit 1.
Yes, Your Honor, that's correct.
Next, allegation 4 in each case alleges that the defendant committed the offense of illegal possession of a firearm by being a felon.
And Your Honor,
after he was convicted of a felon.
I would abandon that just because Miss Adelbert also did state that they were staying there for a short period, so he was allowed to have a firearm in the home. It had been past the 5-year period, so he was allowed to have it in the home at that time of course. Okay,
so you're abandoning 4 on each motion.
Correct. Yes, you are.
Okay. All right, the court, I'm going to ask John West if he has anything he would like to summarize on behalf of the defendant. West, on behalf of the defendant, any summary or concluding remarks you would like to?
Your Honor, I went back and asked him, and I'm going to quote, he stated to me, and I quote, "Get the fuck away from me." So that would be, I have nothing to say on his behalf. I'm not sure what to say.
All right. But it's clear on the record, would you agree that the defendant's been given ample opportunity to be heard?
Yes, Your Honor.
And to be, so long as he is civil and he's been listening in to the proceedings, into the room. You have been discussing things with him through this hearing and giving him opportunities to come in if he wishes, and also pass on any information on his behalf through you. But
The only thing I disagree with that, Your Honor, is I don't think there's, when you say me and him are communicating, there's no communication. I am relaying stuff to him, but he is
he's
not
listening.
Yes, yes.
He can hear.
There's very little communication. He will not
He's not
communicate with
interacting
me.
with you.
Yes,
Okay.
everything is very vulgar and very aggressive. But I've been there trying to at every moment say, "Would you like me to pass anything along?"
Not because of your failure
Exactly,
to
Your Honor.
try
I've
to
been there the whole
interact.
time.
He's refusing to interact with you.
Yes.
Is that right? Okay. One of the allegations here, allegation number 3, evading arrest or detention. Section 38.01 of the Texas Penal Code provides that a person commits such an offense, evading arrest or detention, if he intentionally flees from a person he knows is a peace officer attempting to lawfully arrest or detain him. And this court finds beyond a reasonable doubt that the testimony is clear from the witnesses that the defendant did flee, knowing he was fleeing from a peace officer who was attempting to arrest him. It is on the video clearly showing the chase and the apprehension made by the fleeing defendant, made by the officers of the fleeing defendant after a chase, after being ordered to stop and the officers did have lawful cause probable cause to arrest the defendant and attempt to stop him and detain him and then chase him to arrest him as he fled from the officers. That is clear. Each of those elements are proven beyond a reasonable doubt. Allegations 1 and 2 allege the defendant committed aggravated assault with the use of a deadly weapon. And the offense of assault under section 22.01 of the Texas Penal Code provides that a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another person, including the person's spouse, or intentionally or knowingly threatens another with imminent bodily injury, including the person's spouse, or intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe the other person receiving the contact will regard it as offensive or provocative. And here it is clear from the evidence of the witnesses that the defendant did cause bodily injury and or did threaten others with imminent bodily injury and or did cause physical contact with others, knowing that they would reasonably believe that the defendant would know or reasonably believe that the person he was assaulting would regard it as offensive or provocative. Furthermore, section 22.02 of the Texas Penal Code provides the offense of aggravated assault, and a person commits an offense of aggravated assault if he commits assault as defined in section 2201 of the Texas Penal Code, that the court has found that the state has proven beyond a reasonable doubt of the various ways that the defendant committed assault. If while committing assault a defendant uses or exhibits a deadly weapon during the commission of the assault, it becomes aggravated assault, a felony offense. And it is clear that a deadly weapon, namely a firearm, was used in the course and the commission of the offenses of assault beyond a reasonable doubt. So allegations 1, 2, and 3 in each of these motions to revoke probate, unadjudicated probation have been proven true and beyond a reasonable doubt, much less probable cause, but it's beyond a reasonable doubt. And thus, these motions to revoke unadjudicated probation shall be granted, and the defendant's deferred or unadjudicated probation is hereby revoked. One last time, I'm going to ask Tommy if you'd ask Mr. West if he has any additional items to say regarding further proceedings here. Thank you. Okay, anything further as the court has revoked the defendant's probation by a preponderance of the evidence or greater, actually beyond a reasonable doubt based upon the evidence presented. And Mr. West, is there anything in addition that you would like to add for the record on behalf of the defendant as the court makes its further findings?
No, Your Honor, again, there's no communication between me and Mr. Harper. He refuses to actually speak to me every time I make an appearance. He tells me to get away in very rude manners. And so there's nothing I can say on his behalf.
And does he continue to refuse to come out here to speak and deal with the court in these proceedings in an orderly fashion?
I think he wants to come out, but as far as orderly fashion, that's a different story.
Is there any reason to believe that he would be orderly, or would he conduct himself as he's always conducted himself, coming out in the courtroom in past hearings and also earlier today? Is it your belief that he would be contentious and would not be civil in his demeanor and his statements that he would make?
Your Honor, I don't believe, because you can hear he's still yelling from the back, and even though I'm the only person that's there on his side trying to help him, he still refuses to even be social and cordial even to me. So I don't have a reason to believe that it would be any different to the court or anybody in this room.
We're not going to insult the integrity of this court with his obvious contemptuous behavior. All right. In each of these two cases, in cause numbers 23-41343 and in cause number 23-580, for which the defendant was placed on deferred or unadjudicated probation, that being the aggravated assault family violence in 41343 and in this, which was a second degree felony, and in cause number 23 CR 580, the second degree felony of unlawful possession of controlled substance, namely methamphetamine. The defendant on August 21st of 2023 entered pleas of guilty upon being represented by legal counsel to each of these felony offenses. He pleaded guilty voluntarily, knowingly, intelligently. There was sufficient evidence supporting his guilty plea from State's Exhibit 1 admitted in those hearings, which detailed the waiver of all rights in the making of these pleas, and that he was making his pleas voluntarily, knowingly, intelligently, and based upon discussions with his attorney. The court at that time deferred any findings of guilt, placed the defendant on deferred or unadjudicated probation for 10 years in each case. Based upon the findings today in the motion to revoke unadjudicated probation hearings on each of these two cases, the court has revoked the defendant's probation, as the court finds that the state has proven allegations 1, 2, and 3 of the motions to revoke unadjudicated probation beyond a reasonable doubt. Thus, his deferred or unadjudicated probation is revoked. And the court hereby now finds the defendant guilty beyond a reasonable doubt in each of these two cases. The defendant has continued through this hearing to shout insults and derogatory and vulgar remarks from the holding cell next door to, as we can hear him, just a few feet, approximately 10 feet away from the doorway into the courtroom here, and has refused to act in a civil fashion, and has been banging on the steel door in an obvious attempt to try to disrupt the proceedings at all times during this hearing. Nonetheless, we have moved forward, giving the defendant all opportunities to act civilly, to be heard, as provided an attorney, a licensed attorney, one of our public defenders, John West, has been next to the cell, ready, willing, available to speak on behalf of the defendant and pass on any information, and also meet with the defendant on any advice if the defendant wished. The defendant apparently has decided not to seek any help and just act in defiance. This court now finds the defendant guilty beyond a reasonable doubt of the aggravated assault, family violence, a second-degree felony in cause number 23-41343, and the defendant being found guilty beyond a reasonable doubt. The court has reviewed the pre-sentence information, and this court sentences the defendant to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years. It shall be shown on the judgment that the defendant used a deadly weapon, namely a bat, in the commission of this offense. And also that the victim in this case fit the definition of a family member as proven by the evidence in the taking of the plea, and also during the course of this hearing, and that it shall be showed that the defendant that shall also affirmatively show not only a deadly weapon was used, namely a firearm, but this offense was committed against a family member, and thus an act of family violence under the statutes, under the penal code, shall be shown to be rendered as part of the commission of this offense. In cause number 23 CR 580, as well, the defendant had pleaded guilty to this offense, a second-degree felony of illegal possession of a controlled substance, namely methamphetamine. He pleaded guilty voluntarily, knowingly, intelligently. There was sufficient evidence at his guilty plea to find him guilty beyond a reasonable doubt. His punishment and sentence was deferred, and he was placed on deferred or unadjudicated probation and not incarcerated. Now, based upon the evidence of this hearing and based upon the evidence shown, the motion to revoke unadjudicated probation in that case was proven to be proper and shall be granted, as allegations 1, 2, and 3 have been proven true by beyond a reasonable doubt, as the defendant committed aggravated assault and evading arrest while on probation. Thus, his probation now being revoked, the court hereby finds the defendant guilty beyond a reasonable doubt of this second-degree felony and hereby sentences the defendant to confinement in the institution of the Division of the Texas Department of Criminal Justice to serve a term of 20 years confinement. These sentences shall run concurrently. Is there anything else that we need to add for the record on behalf of the state?
Yes, Your Honor, just to be clear, State's Exhibit 2 was 911 calls entered through Carolyn Lewis. That was admitted by the court. They just didn't play it. So I would renumber. The others are still, I put 2A for the photographs that were 2 through 6, State's Exhibit 2 through 6. I just put 2A, rename that as 2A instead of 2 on the photographs.
Okay. I think the record shows that.
It's something to say.
This court has been doing this for 18 and a half years as a judge and since 1979 as an attorney, as not only a criminal prosecution in the United States district courts, also in state courts, and also defense work, as well as civil practice. This court, this is a first impression of the thousands of cases this court has dealt with, this judge has dealt with. I've never had to really deal with a defendant acting as obstreperous as this particular one. And it, of course, defies any logic since in an abundance of caution, the record shall reflect that Dr. Ed Grapon, licensed psychiatrist, has evaluated the defendant twice on December 9th of 2024 and just 2 weeks ago, based upon the defendant's outbursts. And each of the evaluations reflect this psychiatrist's clinical and expert opinion that the defendant is competent and his obstreperous acts or his own volition, as his experience, as Dr. Grapon's experience with him on these 2 occasions was that he dealt with a man who calmly and articulately interacted with the psychiatrist. And it is clear from his reports, as he states, that there is no evidence of mental illness, of psychosis. The defendant is certainly competent, and most importantly, that his actions are based upon his volitional choice and are not driven by any diagnosable mental illness. And even this court's experience in the last hearing, as the court was walking by to get to the court's offices, we have to go pass by the holding cells. I was passing by and he recognized me and was attempting to speak to me in a very calm voice, attempting to get my attention, but I moved. I did not elaborate and stop with him, but I could hear him speaking to me, and he was not acting in the bizarre, wild fashion that he acted during the hearing on that other occasion. And then during this hearing, as we were holding this hearing, as he was shouting, screaming, uttering vulgarities, and banging on the steel doors in an attempt to prevent these proceedings from properly moving forward. So these are the findings of the court. Anything else to add by the state?
Nothing further from the state.
We are in recess. Thank you.